Good evening, friends, and thank you for being with us tonight. Welcome to the Daniel Webster Debate Series, hosted by the Georgetown Law Federalist Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of our Constitution. For our resolution tonight, we ask, is it time for DC statehood? Especially as students at a DC law school, this debate is of remarkable importance. Who knows, depending on the answer, one of you in this room could be DC's very first senator. We are humbled to have such incredible speakers here with us to discuss it. First, we're deeply honored to host the Honorable Judge Timothy Kelly of the United States District Court for the District of Columbia as our esteemed moderator. Most important, Judge Kelly is a Hoya alum. Let's give him a round of applause. Yeah. To lead us off tonight, we have George Washington Law Dean Allison Morrison. To meet his challenge, we're thrilled to have Dr. Roger Pallone of the Cato Institute. When we first started this series, I could not believe the success and the great year we would all have together. This is our final Daniel Webster Debate Series. I'm so grateful to all of you who made it possible, who've come to these debates, to our speakers, to our judges, our moderators, who have made it so wonderful. The level of civil discourse and substantive debate we've been able to bring to Georgetown has just been remarkable. No other law school in the country has been able to do it, to host this level and quality of spirit exchange and free thought. We're just so grateful to everyone who's made it possible, and to all of you who've come week in, week out to enjoy it with us. With that, we're deeply grateful to the Federal Society and to Georgetown Law to make the Daniel Webster Debate Series a reality. I now recognize our outstanding Director of Debates, Mr. Ian Stapleton, who also has helped make all this possible, to introduce these three stellar panelists. Please give them a very warm welcome.
The Honorable Timothy J. Kelly serves as a district judge on the United States District Court for the District of Columbia. Judge Kelly previously served as Chief Counsel for National Security and Senior Crime Counsel, Senate Judiciary Committee Chairman Charles Grassley. He also served as a Republican Staff Director for the Senate's Caucus on International Narcotics Control. Earlier in his career, Judge Kelly spent a decade as a federal prosecutor, serving first as an Assistant United States Attorney in the District of Columbia, and then as a trial attorney in the Public Integrity Section of the Department of Justice Criminal Division. Judge Kelly also spent several years as a civil litigator at Arnold and Porter. Judge Kelly clerked for Judge Ronald L. Buckwalter on the United States District Court for the Eastern District of Pennsylvania. He received his A.B. cum laude from Duke University and his J.D., as we now know, from the most esteemed legal education institution in the country, Georgetown University Law Center, where he was a senior associate editor of the American Criminal Law Review, and as I can personally testify to from last summer, a fantastic boss as well. Dean Alan B. Morrison is the Lerner Family Associate Dean for Public Interest and Public Service at George Washington University School of Law, where he is also a professional lecturer in law. For most of his career, Dean Morrison worked for the Public Citizen Litigation Group, which he co-founded with Ralph Nader in 1972 and directed for over 25 years. He has argued 20 cases in the Supreme Court, and he currently teaches civil procedure and constitutional law. He is a member of the American Academy of Appellate Lawyers and was formerly its president. Among other positions, he served as an elected member of the Board of Governors of the District of Columbia Bar, a member and then senior fellow of the Administrative Conference of the United States, and a member of the American Law Institute. He is a graduate of Yale University and Harvard Law School, and he also served as a commissioned officer in the United States Navy. Dr. Roger Pallone is a senior fellow with the Cato Institute Center for Constitutional Studies, which he founded in 1989 and directed until 2019. He is the inaugural holder emeritus of Cato's B. Kenneth Simon Chair in Constitutional Studies and the publisher emeritus of the Cato Supreme Court Review, which he founded in 2001. Prior to joining Cato, Dr. Pallone held 5 senior posts in the Reagan administration, including at the Office of Personnel Management, the Department of State, and the Department of Justice. Among other awards, Dr. Pallone received the Bicentennial Commission's Benjamin Franklin Award for Excellence in Writing on the United States Constitution and Columbia University School of General Studies Alumni Medal of Distinction. Dr. Bilon holds a BA from Columbia University, an MA and PhD from the University of Chicago, and a JD from the George Washington University School of Law. Without further ado, I will hand it over to our esteemed moderator. Get things started. We got one more round of applause for our amazing panel.
Thank you so much, Ian. I can see from before I even go any further, let me just say this chapter, this is the last, as many of you know, this is the last installment of the Daniel Webster debate series for this year, a year that has seen this chapter win Chapter of the Year at the National Convention, as well as the debate championship in that same at the same convention. You all deserve a round of applause. That's an amazing record and an amazing debate series you've had for the year. So I think you all should give yourself a round of applause. As an alum of this school, it makes me so proud to be observing this and seeing the success of the chapter and the success of this debate series. One of the things Georgetown you all are gifted with is being in a place where you have amazing people to come speak to you. So this was just a perfect thing, and I've observed this series as it's gone on throughout the year, and it has been it's made me very proud to be an alum. So congratulations to you all. I noticed in my little run of show here that my introductory remarks are longer than the time for each of Morrison and Mr. Pilon. And so I'm going to tell you right now, I'm going to do my best to not use that. But what I am going to do is just sketch out one little story that connects to our topic that I think when I heard it for the first time, made me fascinated. One aspect, we're gonna hear from, I'm sure, both of our speakers about the different constitutional provisions at issue here, and in terms of the sort of, for lack of a better way to put it, the sort of policy or normative arguments about do we want DC to be a state? I think we're all familiar with the overall concept or the overall issue of that 700,000 people here in the city don't have a representative in Congress, and that that's sort of the driving force political force behind the idea that DC should become a state. We're all familiar with that. There's another story that I just want to tell that, again, when I heard it and the way it connects to the concept of making DC a state, I thought was super interesting. So imagine it's 1783. You're a member of the Continental Army. It's summer. It's hot. You haven't been paid in a while. And the worst part is you're in Philadelphia. In June of that year, a whole bunch of folks that found themselves in those shoes. I clerked in Philadelphia. I met my wife there, so I feel like I can make that. And they took half the nationals, so I feel like I can make that joke.
And they won the Super Bowl.
They did. But I don't recognize that. But anyway, and so a bunch of about 500 members of the Continental Army that were in that exact position staged what is called the Philadelphia Mutiny, and basically barricaded the Continental Congress into Independence Hall, seeking their pay. And that event, it was only within a day or two after, and so I think it was Alexander Hamilton talked them back. And the first thing the founders did was go see the I guess it was the governing council of the Commonwealth of Pennsylvania to say, hey, look, we really need protection for our national legislature. Can you all here in Pennsylvania provide that? And I don't really know the details, but the Pennsylvania government declined to provide that protection. And so within a day or two, the Continental Congress left Philadelphia and spent the next 4 years hopscotching between, you all know, between Princeton and Annapolis and Trenton and eventually New York. And I think it was like 4 years later that they eventually come back to Philadelphia. But the point was that that event played a real role in the founders deciding, hey, we need to carve out a special district, an enclave, where the federal government could have its seat and not be beholden to or dependent on any state for everything, including its physical security. Now, I'll just tell you, I heard this story after January 6th. And as someone who has seen more video of that day than I want to recount to you, that's hearing this story before then, we all would have said, geez, that's nice, but that couldn't be an issue today. But there we have a situation where, as it turned out, there was no doubt, again, from unfortunately all the video I've had to watch of that day, it was Capitol Police who responded, but also many of the responders were Metropolitan Police Department officers who ultimately report to the mayor. How that, you can just play out in your mind how that might, and of course they responded and did their duty as they should. But how that might have played out if, let's just imagine there was a separate sovereign that essentially surrounded the Capitol, and law enforcement officers reporting to a sovereign who might or might not be aligned with the president or some politicians in the Capitol. You can see how that would create a dynamic that it was exactly that kind of dynamic that the founders, one of the reasons they decided to carve out the district as its own separate seat of government that would not be beholden for everything from water or electricity, but in physical safety as well. So I put that out there as a interesting story that I don't think many people know, that connects into DC statehood and the reasons we in fact have a District of Columbia in the first place. So again, I'm sure we're going to hear, I don't know if we'll hear about that story, but we're going to hear a lot about the ins and outs of the constitutional provisions and the pluses and minuses of DC statehood. I thought I'd just tell that story to set the stage. So without further ado, let me recognize Dean Morrison for what I'm told is 7 minutes. Thank you.
So if the question is it time for DC statehood? The answer plainly is no, because that has to go through both houses of Congress and signed by the president, and that's not going to happen. So
All right,
the end of the
all right, everybody, here we go.
If the question is, should it be time? That's what I'm going to talk about. It's time because it's fair. We have in the district more voting citizens than do 2 states, Vermont and Wyoming. We pay more individual federal income tax per person than any state in the country. When the war comes along, we get drafted like anybody else gets drafted, and we serve. That's kind of and we don't have a vote, but I want to talk to you about the real consequential harms, which many people are not really aware of what happens. So the first thing is that every single law that the District of Columbia government passes can be overridden by Congress. For any reason, no reason, as long as they got enough votes, they can override it. Some of the laws that we want to make change require the affirmative approval, not negative. The biggest problem, and it's the biggest problem largely because of the House of Representatives, is the riders. The riders are all negative. You may not do this, you may not do this, mother may I, that kind of thing. And they do it, and we of course have nobody in the House to defend them, to stand off, and to negotiate with them about what are we going to get in exchange for. So we can't, as you probably know, the federal law forbids the spending of federal money in Medicaid for abortions. States can spend their own money for abortions for Medicaid, but the District of Columbia can't. It's our own money, we can't spend it. When we wanted to open cannabis shops here, It took us years before we got final approval, before our overlords in the Congress would let us do it. And then let's talk about our governance. The rules about primaries are set in our charter, which was approved by Congress, enacted by Congress. It says we have to have party primaries. We have no choice about that. And that can only be changed by the Congress. The size and composition of our city council is controlled by the charter, which means that the Congress has to control it. Most people are not aware of it, but there are 8 wards. Each ward has a representative. There's the chairman of the city council, and there are 4 other at-large representatives. By the city charter, only 2 of those others could be the same political party as the chairman. Now, it happens in the District of Columbia. At one time, there were 70% Democrats and 30% Republicans. I think it's upward of 95% up there now. And we are told that we must have 2 other people. Now, it would be actually a real big problem if we had to elect 2 Republicans or 2 real independents. But actually what happens these days is that most of the people who run as independents are actually Democrats who changed their stripes just before the election. But we can't change that at all. We can't let them have fewer Democrats. This year we had an initiative, and the initiative said we want to have ranked choice voting. And it's a real problem in the district because we have these primaries, the Democratic primary. There were 7 or 8 people in a single primary, and the winners are getting 12, 15% of the votes. And that means that 80-something% of the people are not voting for that person. And so we wanted to have ranked choice voting. We got passed by 73%. A lot of members of Congress don't like it. I don't know why they don't like it, but they don't like it. And they've already told us effectively, don't even send it up there because it's going to get voted down. And since they can vote it down without any trouble, there we are on our governance. All right, now let's talk about crime. The U.S. attorney, not a local prosecutor, decides which crimes are going to be enforced, what the priorities are, what penalties they're going to seek, and how they're going to allocate their resources. We have no role in that selection. The federal judges here, we don't have a senator to nominate federal judges. Judge Kelly got nominated, even though we didn't have a senator. So, and you had a District of Columbia connection too. That was
I had been living in the district for 25 years and still do.
And you were an assistant U.S. attorney here. And
That's correct.
Yes. But that doesn't have to happen. Many of the judges are not from here. We don't have any control over that. When we want to change our substantive criminal law, we can't do that without the permission. As you may have heard last year, the city council, highly controversial matter, changed a lot of criminal laws, and the mayor didn't like it, but more importantly, members of Congress didn't like it, and it got overridden, and we were told you can't do that. If you commit a crime in the District of Columbia and you want a pardon, who do you get your pardon from? The mayor? No, you get it from the President of the United States. That's how you have to do it. And you have to stand in line like every other federal prisoner around the country do. Parole, to the extent it still goes on, still with a federal parole award as well. Prisons, we don't have our own prisons here at all. We send our prisoners out to any place around the country, no place in consideration of where the families can go meet them and do that like that. The Senate, we have no champion in the Senate. We have no bargaining positions. Now, I'm not commenting on the qualifications of Ed Martin, who is the current nominee, but the papers report that the general practice is that there's no hearings for U.S. attorneys, but there's also it's quite clear that the senators have a veto over who the U.S. attorney is going to be for your district. We don't have a senator, and therefore we have nothing to say, and it's not at all clear that we're able to have anything to say about Ed Martin as well. All of the judges of the Superior Court, they are not appointed by the mayor. They're appointed pursuant to a special statute that has what the Congress said ought to be in that statute, including a federal judge and other people as well. Actually, that commission is a pretty good commission. But they send the nominations to the President of the United States, and he decides which one of the 3 he's going to pick, and then they have to go to the Senate. This last time, because we didn't have a senator, we had 12 to 14 Superior Court judges who have to decide who have to do the criminal cases in the district. They did not get confirmed. There was no problem with them. They just sat there because nobody could put up to the head of the line, which, as you know from what the Senate is, that's the question: who gets to the head of the line to get anything done. And the same is true for the DC Court of Appeals. I think that there's a vacancy on the DC Court of Appeals, one of 9. It's been there for 2 or 3 years already, and that happens with considerable frequency just because we can't do anything about it. And then there's some permanent restrictions here. Do you know why the buildings are only so high in the District of Columbia? Because Congress said that's how tall they're going to. Can't be any taller than the Capitol. If you live in the district and you work in Maryland, you have to pay income tax on your earnings in Maryland. We are forbidden from collecting income tax on people who work in the district, including people who work for the district. We can't collect those taxes as well. Huge amounts of property are exempt from real property taxation in the district because of what Congress has said and not because of what we have said. And of course, we have to provide police protection for the president and dignitaries. Almost anytime you cross town these days, you're going to get a line of sirens coming at you telling you can't do it. So most recent and most painful indignity, in my opinion, is what happened at the time of the continuing resolution this year. $1 billion was cut from the district budget. That was not $1 billion that the Congress was spending. That was $1 billion of our own money, which we can't spend for our own program. If that happened to any other state in the union, it would be mutiny. But it's okay because it's the District of Columbia. So I think you'll hear many theoretical reasons why District of Columbia is not yet a state. I think there's really one that counts the most. And that is because if we're elected, there will be 2 new Democratic senators. And that's what the Republicans really are afraid of. Thank you.
Mr. Roger Pilon, you have the floor, sir.
Thank you, and I want to thank the Federalist Society for inviting me to participate. Alan began by taking exception to the proposition. I'm going to do the same, but to a different end. It has all the ring of a policy question which properly belongs in Georgetown's government department. Alan and I are lawyers. This is a law school, although my former colleague and protege, Ilya Shapiro, whose name is not unknown in these quarters, might argue otherwise. So given that, I'd like to tweak the question a bit. Is it time for DC statehood without a constitutional amendment? And I'll argue that it is not. I'll do it by summarizing 3 basic points. First, Congress has no authority to turn the District of Columbia into a state by mere statute. Second, Maryland would need the consent of the state of Maryland to do so. And finally, and most important, even if those 2 conditions were met, the 23rd Amendment would have to be repealed to allow for this, and there's little chance of that. Before I go any further, let me take a moment to explain out of my regular time, to explain what these bills are about. They're about Congress by statute reducing the federal enclave to a tiny section around the Capitol Mall, and then turning the rest of the district into a 51st state. So that's the strategy. So let's begin with the question of Congress's authority. Both the recent bills that have proposed DC statehood and the May 2021 letter to Congress from 39 scholars, nearly all on the left, locate Congress's authority to create a new state under Article 4, Section 3 of the Constitution, the admissions clause. That would be fine if this were a normal admission, as has happened 37 times in our history, most often from federal territory, such as the Northwest Passage, the Louisiana Purchase, the Gadsden Purchase, and so forth. But the question here is whether Congress has the authority to carve out, create, and admit to the Union a new state from territory that our first Congress acquired from two other states pursuant to Article 1, Section 8, Clause 17, for the express purpose of becoming the seat of the federal government, which it's been for over 200 years. The district is not and never has been federal territory in the Article 4 sense, territory acquired primarily to be the source of new states. The district is unique, a sui generis entity, expressly provided for, not under Article 4, but under Article 1, the Enclave Clause, in its clear, unmistakable contemplation of its becoming the seat of the new federal government. And so the clause reads in relevant part, the Congress shall have power to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may, by secession of particular states and the acceptance of Congress, become the seat of the government of the United States. Seizing on the fact that the framers declined to set minimum size for the district, opponents of the bills at issue believe that Congress can carve out this new state and leave the federal government seated in this tiny enclave, all without amending the Constitution. To be sure, the framers set no minimum size for the district, but their mention of 10 miles square, together with Congress's nearly contemporaneous 1790 creation of the district from land 10 miles square, ceded to the federal government by Maryland and Virginia, is strong evidence of what they intended and evidence too against these bills. Some have argued, however, that Congress's power to exercise exclusive legislation in all cases whatsoever over such district entails a power to create a new state from that district. That raises a fundamental constitutional principle, the doctrine of enumerated powers. Search as you will among Congress's Section 8 powers, you'll find none authorizing Congress to carve out a 51st state from the present District of Columbia. To listen to these folks, you think that the Constitution read, all that is not prohibited is allowed. Just the opposite, all that is not allowed is prohibited. That's the preamble. That's the first sentence of Article 1. That's the 10th Amendment. The point was stated somewhat differently in 1963 by Attorney General Robert F. Kennedy, that's Pear, commenting on a bill that would have retroceded the District of Maryland. And I quote, while Congress's power to legislate for the district is a continuing power, its power to create the district by acceptance of session contemplates a single act. The Constitution makes no provision for revocation of the act of acceptance or for retrocession. Attorney General Edwin Meese made a similar point in 1987, and I quote, the Constitution appears to leave Congress no authority to redefine the district's boundaries absent an amendment granting that power. I would add, too, that every Justice Department that has addressed the question has found that Congress lacks such power, with one exception in 2009 under President Obama, after the department's Office of Legal Counsel reached a similar conclusion regarding a district voting rights bill then before Congress. It was Attorney General Eric Holder who rejected the advice of the Office of Legal Counsel and sought the opinion of the Solicitor General's office as to whether they can defend that. Well, of course, that's their job in the Solicitor General's office. Maryland's consent. The purpose of Maryland's cession was made clear in the initial act that gave Maryland's House delegation the authority, quote, to cede to the Congress any district in this state not exceeding 10 miles square, which the Congress may fix upon and accept for the seat of government of the United States. Here again, we have a single act for a single purpose. Maryland did not cede the land for the purpose of creating a new state on its border, nor is it likely it would have done so for that purpose. That point is buttressed by Article 4, Section 3, which provides that no new state may be created out of the territory of an existing state without that state's consent. I would add here that imagine that on day one in 1790, Maryland and the Congress reached the agreement. And a day later, Congress turned around and turned this territory into a new state. There would be political mischief of the first order. The fact that 200 years and more have passed does not change that principle one iota. The 23rd Amendment, we come now to the crux of the matter. Ratified in 1961, the amendment gives the district 3 electoral votes as if it were a state. Ironically, that grant stands today as the greatest obstacle to DC amendment, as even the proponents admit. The problem is that there will still be residents in this tiny enclave, including the first family, and they'll have outsized influence on presidential elections. Yet their voting rights, guaranteed by the amendment, cannot be taken away by mere statute. These bills provide for expedited procedures for repealing the amendment, suggesting that proponents sense that there's a problem here. But repeal is a long shot given the ratification hurdles, so the bill also provides for repealing the statutory provision that enables residents to vote. That, of course, would amount practically to extinguishing the enclave's residents' right to vote. So we do indeed have a problem here. And the scholars' letter airs their disagreements over that problem among themselves. One camp reads the 23rd Amendment as self-enforcing and therefore is mandating the appointment of electors. The other reads it as requiring enabling legislation. And so, absent such legislation, there's no way for those residents to vote. And that camp appears perfectly happy with that result. But even if the self-enforcement camp prevailed, and the district had to appoint electors in such manner as the Congress may direct, as the amendment reads, both camps claim that Congress could replace the current law, which orders electors to vote in accordance with the district's popular vote, with one that mandates that they vote in other ways, in favor of the ticket that got the most electoral college votes nationwide, for example, or for the winner of the national public vote. In other words, these scholars read manner as referring not simply to procedures needed to execute voting, but to legislation allowing Congress to direct electors how to vote. The current statute does that too, but it's entirely consistent with the whole point of the 23rd Amendment, namely to enable district voters to select electors based on which ticket the electors are pledged to vote for in the Electoral College. Enacted prior to any election, such a statute surely cannot direct voters how to vote, but neither could it rightly direct electors how to vote, except as a reflection of the popular vote in the jurisdiction. For otherwise, the amendment would effectively come to nothing. Yet that's precisely what the scholars' argument comes down to. So for these several reasons, lack of constitutional authority, the need for Maryland's consent, and the impediments imposed by the 23rd Amendment, I join the many others who've long held that DC statehood will require a constitutional amendment, which is not likely to occur. Let me conclude on a final point. This is all part of a long train of constitutional abuses and disregard that began at the end of the 19th century with the rise of progressivism, with Woodrow Wilson viewing the Constitution as a straitjacket that prevented him to rule as he wanted to, perhaps under a parliamentary system. It was institutionalized during the New Deal constitutional revolution after Roosevelt's infamous court packing scheme, especially in 1937, with the court's demise of the doctrine of enumerated powers. It was expanded by Johnson under the Great Society, and it continues to this day as the left would democratize the Constitution, this being one example of that, but there are many more. And so with that, I put it in a larger context to see what's at stake here ultimately.
Right. All right, so let me do this. The format calls for a 2-minute rebuttal, but I actually think I'm just going to pitch it back to each of you for maybe even 5 or 6 minutes to do this. You know, one of you, Mr. Pilon, you focused on all the roadblocks aside from the Constitution that you think stand in the way of DC statehood. Dean Morrison, you ran through all the reasons why you think DC statehood is a normative good. So why don't you respond to some of the roadblocks that Mr. Pilon mentioned, particularly the oddity of the 23rd Amendment and what you do about that, and also just the argument that this was that under the doctrine of enumerated powers, while Congress may have affirmatively granted, while the founders and the Constitution granted Congress the right to set up the district, it doesn't give it the right to shrink it, and at least not to shrink it, because we all know, everyone out there knows, Virginia was part of the district at one point and was retroceded to Virginia. But in any event, that regardless of whether that may have been constitutional, at least that to shrink it to a sort of little rump area, basically, that at least violates the spirit of what the founders were trying to do.
No, thanks. Let me start with the 23rd Amendment. Okay. The 23rd Amendment was an empowering amendment for the District of Columbia. It gave them the right to participate. And so what the argument is, aha, it's a gotcha. At the same time as we gave you right to participate for the president, we took away your right to become a state. Well, maybe it's not a gotcha. Maybe it's not an implied repealer of it. But the second thing is they say, aha, but you've got this little enclave, and who's in the enclave? Turns out there's only two people, the president and the first lady. Okay, those are the only two people there. Now, I would.
Maybe
children, but they're not eligible to vote anyway. And besides, most of the presidents are most anxious to vote back where they're from and not where they're okay. But let's suppose that President Biden II, just to pick a name, gets in and the bill comes up and he says, you know, if I'm elected, I will personally campaign for the repeal so that I can't vote 3 votes. And everybody says, oh, no, we won't let you do that. We won't let you do that. That would make it constitutional. Yes, there's a problem. But if you let problems like this stand in your way of what's doing the right thing, I think that you're not being true to what the Constitution is about. And that would get back to the first point I was going to make. Next one.
Alan,
No, I let you talk for 15 minutes, Roger.
It is true.
Or rather, the judge let you talk 15 minutes. I didn't let you do it. When the first Congress was voted on under the Constitution, the people who were living in the territories that were taken from Virginia and Maryland got to vote for the state in the state for which they were doing. And they voted until they came to the district, and then there are not so many of them. And nobody made a fuss at the time, but you don't lose your constitutional rights by adverse possession. And so the understanding was back then that they were going to vote. They hadn't quite figured out how it was going to happen. So if you think about it from that perspective, if you think about it from the perspective that these are American citizens who pay taxes, eligible for the draft, and live in the United States, the only state, no state of the country, of course, has a situation like this. And Judge is right, historic reasons for that. I think the historic reason didn't save January 6th, but that's another story. No country in the world says that the people who reside in their capital area can't vote. And if you ask the American people whether it's right to deprive them of that, I think the answer would be no, it's not right to deprive the people of the right to vote for members of Congress when there are serious consequences in doing so. Yes, the territory clause can be read one way. We are treated like a territory when Congress enacts the laws all the time. They're doing that. True, they cite the enclave, but lots of things are treated like the territories. My own view is that those are barriers that people put up. I do it all the time myself. You don't like something, you got a legal rule, not reason not to do it. That's okay. My view is that if the Congress and the president approved the statehood statute, it would go to the Supreme Court, and the Supreme Court would not overturn it, despite Roger's brilliant analysis. That this is fundamentally a political question, and the question is, are they going to allow it to happen? And shutting off people in the face of democracy, I don't think will happen. Roger's arguments are very skillful and not without some cause for debate, but I think ultimately unavailing.
Mr. Pilon, let me turn it back to you and flip things, flip the ground on which Dean Morrison was arguing to you. Put aside your the issues you've raised, the constitutional, your point that it would require a constitutional amendment. Let's say we had the stars aligned for a constitutional amendment. Talk to me about whether you think, just as a normative thing, it would be a good thing to have DC statehood along the lines that some of these bills suggest. Let me just say, while the founders were not, they certainly didn't extend the vote to all the classes of people that, thank goodness, today the law requires, but certainly they were one of the reasons for the revolution, and one of the bases for the government they set up was representation. How do you think they would, and certainly during all the time that they would have contemplated of course they passed the Constitution before the site here was even chosen. But they never maybe would have envisioned 700,000 people living in this federal enclave without representation in the national legislature, without the ability to pass their own laws, without interference from the federal government, et cetera. Maybe that last part they would have, but certainly maybe they wouldn't have thought of that many people. So what is your view of the normative question of whether it would be a good thing, putting aside the procedural obstacles, about whether the district should be a state, and what do you think the framers would have thought of that?
Well, I have deliberately avoided taking a position
I know
on
it's
merits,
it's my job as moderator
I know.
to make you do that.
and I've done so because I am
Mr.
first
Judge.
and foremost- I've done so because I'm first and foremost a constitutionalist, and we err if we think that the United States Constitution is a democratic republic. We live in a constitutional republic, not in a democracy, notwithstanding the efforts of the last 150 years to democratize everything. In fact, the objections that the objection I tried, or the comment I wanted to make to a point that Alan raised a moment ago.
No, but you need to answer my question.
What?
A good thing or bad? DC statehood, good thing or bad thing?
Well, I think it's a good thing that people have the right to vote. There's no question about that. But you have to bring that about in the right way. We did it, for example, with the 15th Amendment. We did it with the 19th Amendment, which many think was a mistake. And you remember what the 19th Amendment was? Yes. Okay. But I better stop while I'm ahead. When Alan made that point, I was reminded of a comment by Hamilton Fish from New York back at the turn of the 19th century. What's the Constitution among friends? And thus echoing later Franklin Roosevelt writing to the chairman of the House Ways and Means Committee in 1935. I hope you will not allow any reservations about the constitutionality of this bill to stand in the way of its passage. I mean, they knew exactly what they were doing. The Constitution be damned, and they did indeed turn it on its head in 1937. But to get back to a point that Alan made, that early in our history, for the first 10 years, citizens of Maryland and Virginia had the vote. They did, as members of the states of Maryland and Virginia. They weren't voting to elect 2 new senators and another congressman. So there is a world of difference there. The federal government, as you said, Judge Kelly, was established, as Madison made clear under Federalist 43, to ensure that no state would be overly influential on the federal government, and the federal government would not be too beholden to that state for everything from water and sewer and police and so much else. Those are the practical considerations. My concern, however, is with the Constitution, which we have lived under and survived under far better than countries around the world. And I would hate to see it democratized so that, as is increasingly thought today, all you have to do is appeal to not only Congress, but to the president to give you everything in the way of goods and services that you think you want, from student loans, forgiveness, dare I say, in this room, to health and welfare, and you name it, periodic holidays with pay and so on.
And that's equivalent to the right to vote?
The right to vote is merely a means.
Merely.
Merely a
Yeah,
means.
merely. But most of us in the district think it's more than a merely.
In fact, I would rather live under a classical liberal monarchy, as the people in Hong Kong did for a long time.
And look what that got them.
Yeah, well, no, that was pure. Well, yeah, what it got them was the Chinese Communist Party taking over.
Dean Morrison,
And then, of course, and there is an issue here too. It is this: if you have everything reduced, as you have in cities today, to one-party rule, look at Chicago, look at San Francisco, look at New York, then you have a virtual tyranny. And poor government besides.
Here's what I was gonna ask you. Do you think that the practical, so no question, no ifs, ands, or buts about it. The district, if you live in the district, you do not have representation in the national legislature, period. Part of your argument, another maybe larger part of your argument, was about local control of control of district affairs, and how ultimately Congress the federal government is the sovereign, so the laws, one way or the other, whether they have to be approved or whether they can be rejected by Congress, there isn't full sovereignty with the people. But do you think, as a practical matter, that really that really is something that touches the day-to-day lives of district citizens? I say that because I think, take the example, actually, one of the examples you used was that cut into the district budget. You know, the interesting thing about that is the reason that happened to the district was they were treating it like any state. So you were saying, well, no state, that would never have a state. Actually, it was because, in its wisdom, the Congress, or at least the House, said, we're going to treat the district like every other state. We cut every other state, whatever amount it was, and we're going to do the same to the district. Now, a city is different than a state, and there are all sorts of reasons why that was unfair and wrong. I mean, why people think that, but at least they thought, or at least that was the defense of it, that they were treating the district like any other jurisdiction. But put that aside, just across the, or you can address that, but across the board, when I look at, for example, you know, more and more, for example, you have now you don't have an elected district attorney, as you said, but there is an elected attorney general who does not prosecute felonies, but has been kind of expanding the role that person has, elected directly by the citizens. You know, I think there are a lot of reasons there are a lot of reasons to think, I think these days, that on a day in, day out basis, some of the concerns you have don't really come to fruition to affect the lives of district citizens.
So let me divide, if I can, the impact of the lack of vote in Congress to two parts. Part one is we don't have a vote on what the federal income tax law will be applied to everybody, okay? We don't have a vote on that, and okay. That's one category of things, or what the laws will be about pollution,
That
anything. The general laws of general applicability, okay, that's one thing.
Federal law.
The second is all of the interferences that exist because home rule is less than complete.
Right.
And
But
so
does it happen that, you know,
So
that made big news, that one last summer or whenever it was, a couple of years ago, when the crime bill went up in flames.
yeah,
And not just because of Congress, because also because President Biden said, I'm gonna, I
he
think,
was running for reelection.
well, that pesky democracy.
Yeah.
But anyway, but the point is that, that's pretty rare, isn't it?
No, all these riders are happening all the time.
Yeah.
The judges, if we could,
The judges,
the
yeah.
judges, the US attorney versus the attorney
Yeah.
general, if we had home rule instead of home fool, we would be in a different situation. I mean, it was worse for a while. I mean, it's actually gotten less restrictive.
Yes.
And it varies depending on who's running Congress and who's in the White House. But I mean, in that sense, there are two things. The trouble with separating them out is, you know, if you say to people who want statehood, don't give me a half a loaf or a third of a loaf. We want statehood. And so that's the problem. But you are absolutely right in terms of the real world impact. It's not the vote in Congress on matters of general applicability. It's the matters in which most of the things I talked about here were impacted that way. I'm not sure you're right about the $1 billion cut this time. We had a situation a couple of years ago where they treated the District of Columbia like states when they're getting federal money under the. But this one, they just chopped the money right out of the budget, because this is money. They also got caught on the Medicaid. If they cut Medicaid, the district would lose its share of Medicaid like every other state would lose. But this is district money for district purposes.
It is definitely district money. I recall, I thought I saw it being defended that way, whether that's accurate.
Well, it may have been defended that way.
Right.
Yes. Yes.
Okay. Whether that's
100%. It's a really good point about the two different reasons.
Yeah.
Why you know.
Well, thank you.
Well, I mean, I had not analyzed it so much that way. You know, if sometimes there's going to be another draft, for example, we would lose our vote in the draft, but that's a different kind of harm from losing our ability to control our own fate and our own taxes and our own revenues.
Right. Yeah. Mr. Pilon, let me have you respond to anything that Dean Morrison just laid out. Or make any point you want to make.
Well, I would
in
make a
advance.
general point that Alan is basically offering a policy argument, which boils down to a simple point. We don't like living under the thumb of the federal government. Well, no one likes the authority of another, but that's the arrangement that the Constitution established, and it's worked pretty well for over 200 years.
For some people,
So, what's that?
for some people, it worked pretty well.
I don't notice you suffering, neither of you suffering, and you both live in the district.
Actually, I want to, to both of you, I don't know if you all, either of you know the answer to this. It is interesting to me that the framing of this, and I don't think, Dean Morrison, you haven't explicitly framed it this way, but I think these days, a lot of the way this issue is framed is one of civil rights, and particularly civil rights with a real, not just generic voting, but obviously the population of the district. It used to be a higher percentage of African Americans. Now it's less, but it's still sort of talked about in that way. And I wonder, do either of you know when that? I mean, at some point that had to become kind of the way people saw DC statehood for the first time. Was that a product of the civil rights era and the changing demographics of the district? Would 100 years ago people have thought of DC statehood or the fact that folks could not vote here in 1925? Would people have thought of it as a civil rights era in the same civil rights issue in the same way they do today? Do either of you know that?
I don't know, but I mean, the composition of the district was very, very different then.
Right.
And so both racially, and of course, women only got the right to vote in 1920. So
Right.
before that, and people, I think it's definitely different now today. But I think it's less of a civil rights in the way that racial minorities and women are. I think that all of us of whatever race and gender we are in the district feel this, and it's taken. We started with it until 1972 or 3. We were under the complete control,
Right.
And then so we got a few things and got a few crumbs, and then it was not so bad, and then people started saying, well, why don't And then people started to realize when the district started to want to do some things, and then we were told by Congress you can't do them. People started to say, well, wait a second, that's not right. And I think today members of the council are holding back on doing things because they're afraid they're going to get slapped down. And worse, they're afraid that the president has said that he is thinking about retaking the district and wiping out home rule entirely. I'm not sure he really wants to be in charge of the police and the garbage collection and everything else in the city, but maybe he does. Maybe he does.
Judge Kelly, let me address your
Please.
question as follows. For most of our history, no one thought that a proposal of the kind that is now before Congress and this body would have been possible without a constitutional amendment. President Lincoln thought the Virginia retrocession was unconstitutional. So did Teddy Roosevelt. So did Chief Justice Taft and many others. When the 23rd Amendment was passed in Congress and sent out for ratification, nobody thought that it could be done other than through amendment, this provision of electors for the District of Columbia. When the 1973 bill affording statehood for the district was sent out for ratification during the 7-year period, only 16 states had ratified it by the time the period was up. In all of this, nobody thought that this could be done without amendment. So what changed? Well, the Democratic Party changed, and it increasingly became inured of the idea that you could accomplish what you want by mere statute and forget the states. For example, cooperative federalism versus competitive federalism. Competitive federalism arises when states, when citizens in the state vote with their feet because they don't like the taxation, regulation, or whatever in their home state. When you have cooperative federalism, whereby after the 16th Amendment, all the money flows to Washington, and then Washington parcels it out for programs that it wants, which the states may not want, then you have a diminution of the virtue of competitive federalism, and you've got what's called cooperative federalism. And it's a much harder, it results in the inurement of power to Washington from the states. These are some of the things that have led to the aggregation of power in Washington. And I can illustrate it no more clearly than with a statement from Rexford Tugwell, who was one of the principal architects of the New Deal, a member of Columbia economist who was a member of the Roosevelt Brain Trust. Reflecting on his work some 30 years later, he wrote, in order to engage in the programs that we did, we had to engage in tortured interpretations of a document that was intended to prevent them. They knew, again, exactly what they were doing. They were turning the Constitution on its head, reading it as a document that allowed everything that was not excluded. Contrary to the original understanding, the founders, after all, stood for limited government, and the anti-federalists stood for even more limited government. There wasn't a socialist in the bunch.
Well, I think that's about all the time we
Did you
have.
have Q&A from the audience?
Well, we were going to, but you all were going.
Well, no, we can.
No, if, oh, great,
We take a couple.
fantastic. Please, I'm glad.
Look, and I
you don't
don't
have
have
to
to
go.
go drinks and dinner for a little bit.
Go right ahead.
So in 1805, the Marshall Court interpreted the diversity jurisdiction clause to exclude DC residents from being able to sue the residents of other states in federal court. That right there seems to be a distinct disadvantage, both normative and constitutional, of DC remaining a territory. Granted, that was fixed in the 14th Amendment, but given how long that lasted, given the other disadvantages like a lack of voting representation, don't you think that the constitutional barriers that have existed and continue to exist in many ways in order to sort of realize the effectuating goal of no taxation without representation sort of should be in the game plan regardless of the political consequences?
Thank you.
Well,
I think
that's
directed to you.
That's a wonderful political slogan, but it's not borne out by the text of the Constitution. So if you're a textualist, you'll want to take note of that.
And don't you think that Congress should work to, within the constitutional process, change that?
Sure, within the constitutional process. Problem is, you're going to have to get 2/3 of the Congress and 3/4 of the states. And given the politics of the district, where not a single Republican exists except undercover, you're not. I'm going to look at, what was it, 90+%. It makes Vermont look like a River Rock Republican enclave.
Which it used to be.
Please.
Evening. Thank you all so much for this discussion. I am from Bethesda, so like,
Can you speak up a little?
sure, I'm from Bethesda, so I'm relatively local.
Oh, hi, yes.
Oh, perfect. And so this was like dinner table conversation in my household a bit. And I've got, a parent who's in the federal government and my family who's not theoretical or constitutionally inclined whatsoever, very pragmatic, always was against statehood because they felt like everybody's already involved and has a means of influencing the government that isn't in the ballot box, but could be lobbying, or you could be actually employed by the government and have, like Judge Kelly, for instance, has, in my opinion, a bit more of an ability to influence.
In a very narrow set of cases that I have no interest in, but yes.
And you had no choice of picking.
Know a judge who is working on a case, and you would not do this as a judge, but do you know what I'm saying? Like, there's so many people who live here
Sure.
with a much greater ability to influence than you have in the.
That's a
spots.
fair,
The people in Chevy Chase don't have that kind of influence, the people in Alexandria.
Right, my dad has both because he's federal government and he's Maryland, so he can vote and.
So,
So you could move.
Yeah. Then you raise a very good point, and it's this, that the citizens of the District of Columbia may not have a vote in the traditional sense, but they have access, easy access to any member of Congress. They simply can
all
walk right up.
700,000 of us,
Pardon?
all 700,000 of us.
No, they
The
can
people
simply
in the
walk
costume?
right up there, make
And
their
you
case
can't walk in the
out,
building anymore.
and you don't, whereas the
Like
people in
Georgetown.
California have to fly in and talk to their congressman, and their vote, one vote out of 180 million other votes. As I said, I hate to say it because it's often misunderstood, but voting is one right, liberty is another. And if you've got a government like the people in Hong Kong had for ages, you're far better off than having a vote
That's your.
as your remedy, because it's one of 180 million.
Yeah,
Right here.
Thank you, gentlemen.
I'm sorry. We can take one and then one. Yes,
Just a
go
quick
ahead.
one, just for the dean, does your pragmatic, I guess prescription, does that apply to like other territories like Puerto Rico and Guam?
So Puerto Rico. So the first thing is Puerto Rico is configured very differently. The people the people in Puerto Rico have huge breaks that the Congress has given them. If the Congress were willing to change and they wanted to do it, my principle would be the same. But it's kind of ironic that Puerto Rico could become a state under Roger's theory, but the district could not become a state. I mean, maybe that's it's not necessarily conclusive, but it would be certainly ironic.
But they generally vote against statehood. They've had their vote many times.
Well, actually, the problem is it's split three ways. That some people want Commonwealth status, some people want statehood, and some people want to keep it the way it is. And since they can't get two-thirds majority on any, let alone 2/3.
And the Democrats want both Puerto Rico and the district to be states, and we know why.
Well, Puerto Rico elected a Republican governor for quite a while,
Yeah.
so it's
Yeah.
not at all.
The times
And
they are.
when Alaska and Hawaii were admitted to statehood, everybody thought that Alaska would be for the Democrats and Hawaii would be for the Republicans. So you just
So much for conventional wisdom.
Yeah, this has been so great, gentlemen. So thank you all. But quick question on the security aspect, right? So it seems like on the one side, like removing the federal government to just a really narrow enclave would have real security risks if it was a different National Guard that maybe protected it, maybe didn't. But on the flip side, like we have federal enclave now, and it didn't work super well to stop a January 6th like event, like a real attack on the court or on Congress. So is it kind of doing its job now? And if we got statehood, would it do its job even worse?
I think that the federal government has enough power that if it worried about protecting the president, they could do it even if we had a statehood. Yeah, you would after January 6th, people would worry more than they worried before January 6th about it. But I don't think that that's a good reason. The judge is absolutely right. It's an interesting historic fact, and it was much more a problem back in 1789 than it is today. Yeah.
Well, the Confederation Congress fled to Princeton, our Congress fled to the coat room or something like that. didn't it?
An undisclosed location.
Yeah, undisclosed. location.
Thank you both.
Thank you very much. Thank you, John.